It's time for coffee and cursey words. Happy Tuesday. I feel like it's been forever since we've been live. My voice is still a little hoarse. It's okay. We've got so much to talk about. Hopefully, you won't notice too much. Today, it is Tuesday for coffee and cursey words. We have a quick bits, and then we have Tati updates, and then we have a lot of Britney updates. The big minute order that I have been waiting for uploaded literally this morning. And that is what I was waiting for. So I was scrambling to pull it up. My light's not working. Having some technical difficulties. We're professionals here, people. We just roll through it. Look, even at Vid Summit this week, there were technical issues, and they had the most amazing content creators on the planet, like Mark Rober and Peter McKinnon and Mr. Beast and Game Theory, Food Theory. Matt Pat, who was amazing, Graham Stephan. Anyway, we're going to talk about what I was up to last week when we get to Q&A. But first, we are going to get to quick bits, Tati updates, Britney updates. So content first, then questions, and then I'll talk a little bit about Vid Summit and all the things. So let me know where you're coming in from. Cheers, we're live. It's Tuesday. We got a lot to do. Should we just go? I think we should go. We should just go. Hey there. If we haven't met yet, I'm Emily D. Baker, the badass lawyer and everyone's favorite legal commentator. I'm the host of The Emily Show, and I break down the legal shit behind the news and pop culture stories we all want to talk about. I have been a licensed attorney for over 15 years, but this is not legal advice. I should warn you, I'm a big fan of the cursey words. This channel is where the law nerds unite to talk about facts, not fuckery. You know, there are people that have asked me, why do you do Tuesday mornings? Especially with COVID restrictions lifting here in the US, Tuesdays don't always get the same amount of live viewers. And it's because of our incredible international audience. I see y'all coming in from everywhere, from the Philippines and Ireland and Germany and Latvia and the UK and all over the place. And that is why I love having coffee and cursey words, because for some of you it's coffee and for some of you it's like an evening drink. But I know that sometimes the Friday night lives are way too late for our international crew. And there are a lot of you, trust me, I see it when particularly Emily's Show podcast ranks all over the world. I can see where you guys are coming in from. So thank you. Hello, Lithuania and Denmark and London and Canada and Scotland and all of the places. It's so good to see you coming in. So yay. We need to get to quick bits. I have a lot to talk about. It's a lot. I'm going to touch on the hunt for Brian Laundarie first, real quick. Just because I have some thoughts, I want to share them with you. There have been some updates. I don't know if it will help with anything, but I hope that it might. And just, I mean, I have thoughts, and sometimes we just share the thoughts with you, right? That's what we do. We share thoughts. And so much has happened in the kind of the hunt for Brian Laundarie on the search warrant that's still out for him with regard to the use of an access card, that I think it might be helpful to talk about it and to also talk about why there are, why, like, his sister's been told not to talk to the police. I should just swoop and get into it instead of telling you I'm going to get into it. Look, people, it's Tuesday. This is still very full. We've got to get way down into the coffee before. Oh, also, I keep forgetting. YouTube has been reminding me, hey, maybe you should remind people to subscribe to your channel, like in my YouTube studio. So, hey, if you're not subscribed, go ahead and do that. Subscriber mode is on for the chat. It makes it easy for me and the mods, and it reminds you if you're not subscribed. So if you like the content, go ahead and subscribe. It's free. And if you hit the bell, then YouTube will kind of sometimes maybe tell you when I'm live. Maybe, perhaps. So let's talk about the hunt for Brian Laundarie. He is still a wanted individual. He is wanted on a search warrant with regard to use of an access device to access a bank account. It is presumed by me and others that was Gabby Petito's bank account. We don't know that for sure. We do not have the rest of the autopsy released. With regard to the death of Gabby Petito. The manner of death was ruled homicide, meaning it happened from someone else. That doesn't mean that we know who that was. We do not know the cause of death, things like that. So there can be accidental homicides. Not that I'm saying that happens in this case. I'm just saying the coroner designation and a criminal designation are not exactly the same thing. So with that, I don't think we will see, and I know people are frustrated and anxious. I don't think we will see a release of more of the coroner's report unless they decide to charge Brian Laundarie or someone else in the death of Gabby Petito, because when you need to question people, when you need to interview people, particularly when the FBI is involved in that, there are certain things and certain amounts of information that you don't want the general public to have, because unfortunately and sadly, in high profile cases, you will sometimes get people who admit to things for the notoriety. Not because they were actually the one who did the thing, but because they want to be like a part of it, which is a weird thing. But the more information that's out in the public, the more people can put those types of things together. And that can be detrimental to an investigation, because what they don't want to do is run down every wild goose chase lead. So, there are things that will absolutely be held back, as it should be. This is still an investigation. We still don't know. And we can see Brian Laundarie charged if they determine that he should be charged. In the death of Gabby Petito, while he is still unaccounted for, on the run, missing, you pick the word. You pick the word that works for you. But they can do that if they want to do that. They may or may not. It just depends on all of the evidence that they have and how they want their investigation and interviewing in the future to go. Now, with that said, I have seen lots and lots of people outside of Brian Laundarie's parents' house, outside of his sister's house. Look, uh, people have the right to stand on the street and do what they want. It does not sit well with me. His parents, I don't like the way they behaved either. Look, I tell you when I don't like the way people behave on this channel, but the way people behave and the morality of the thing and the legality of the thing are two different things. And what's really hard for me to watch is not just the dissecting of this on social media with just post after post and misinformation and speculation and this almost gamified dissecting of this case, while those who love Gabby Petito are trying to heal and find answers. And truly, they're the only ones who are entitled to answers. The rest of us are not entitled to anything. But watching people stand outside the Laundarie's house demanding answers, it's not going to help. B, it's harassing his parents. I don't like the way his parents have acted either. I think it's highly sus. I think that's up for the FBI to deal with. I really do. I think that's for them to deal with. I think the harassment of the parents and the siblings doesn't make sense and could make this investigation harder. And the misinformation can actually bolster a defense case if he is charged in other things down the road. And while I understand reporters being outside of the house and I understand people accounting for their whereabouts, I don't understand the screaming at the house. I don't understand the demanding to know. No one's entitled to anything. They are entitled to stay in their house. They're allowed to not say anything. They're allowed at this point to not cooperate with police. That could have ramification down the road. It could. So it's just one of those things that I struggle with too. I think first of all, having media, like actual media, real reporters, real journalists, I am not one. I am a commentator with a law degree and a lot of legal experience and some opinions and a microphone. But having journalists out there, there are some boundaries. Just having people out there screaming harassment at the family is different. I feel bad for his sister tremendously. Like, we're not responsible for what our family members do generally. She doesn't seem to have helped him in any way. And her family, where her kids live, is, being subject to harassment. And I think that that's awful. I really do. So hopefully the misinformation and the dissecting will stop. Hopefully we will see actual information, like the individual that said that he was out on the Appalachian Trail. And yes, I have learned since moving to Tennessee, because I am friends with Jessica Stansberry, who went to Appalachian State, that it is Appalachian and not Appalachian. And if you say Appalachian, you are doing it wrong, and it's Appalachian. Once again, I trust the girl that went to the university and love Jessica Stansberry. She's a content creator here on YouTube and a dear friend. But somebody who was out on the Appalachian Trail saw someone who they believed to be Brian Laundarie and has reported that information to law enforcement. Good. That's exactly what should be happening. See something, say something, and keep an eye. I think keeping the story in the media is helpful. I think dissecting it is not. Where is that line? It's up for everybody else. There's a reason that I cover this sparsely, because there isn't a ton of new information. We saw more information from Brian Laundarie's sister. She's just trying to stop being harassed, really. And it seems like she's giving an interview, even though law enforcement asked her not to. When law enforcement says don't, there's a reason, and interviews generally are part of that reason, because defense attorneys can come in and be like, look, they knew this information not because they did the thing. They knew this information because of what was out in the media. And it's really interesting to see cases from the prosecutor perspective. I was a deputy district attorney for over 10 years in LA County. From a prosecutor's perspective, to see defense attorneys latch onto, well, what they said in the interview wasn't the thing. And we see this with the Josh Duggar case. We see that contemporaneous statement made before he interviewed with police. What he said was, they asked, like, hey, we're going to interview you, we're going to do this. And he's like, so was somebody downloading CP here? Now, if the media had been like, oh, Josh Duggar is going to be rated for this and that, then his defense attorney could get in there in trial and argue, look, he's asking because he was seeing this on the media. He's not asking because he has a consciousness of guilt. He's not asking because he knows exactly what's happening because he's doing it. He's asking because that's what he saw. And it's a different type of testimony, because a contemporaneous statement, oh, was somebody doing this thing that's exactly what you're here for, at trial from a prosecutor, is a very, very powerful admission of consciousness of guilt, because he wasn't told what they were there to investigate. It's a car lot. Could have been financial. Would have been most of my guess. A car lot gets rated O. Is there a financial issue? But no, that's not what he suspected. And because of that, the prosecutors have a great statement that they are going to be able to use if the Duggar case goes to trial after he lost all of his motions in court. So that is why I am hesitant when there is speculation, but not a little. The dissecting of little bits of information is just hard for me. I'm just going to leave it at that. So we have someone who thinks that they saw Brian Laundarie on the Appalachian Trail. Dog the Bounty Hunter is apparently on the case. He had indicated that he thought that the Appalachian Trail might be an area where Brian Laundarie goes. How much time Brian Laundarie had to get together the things you need to survive on the trail. People will see you on the trail. It is still hiking season. I mean, we're getting into not easy hiking season, but we will still see if he had help doing those things, it will come out. If he went and purchased things, it will come out. If he goes into town, there are cameras, it will come out. Sometimes it's hard to wait, but investigations need to unfold, and we want them to be good investigations and clean investigations, because you don't want them getting thrown out later on appeal, because at the end of the day, the defendant has a whole lot of constitutional rights that can't be violated. And it's just hard to watch. It's really hard for me to watch how much how much diving into this case has happened. It just makes me sad. So that's why I'm not covering it a lot. That's why I am That's why I am hesitant when there's not new information. If there is solid information, I'll share it. If there's speculation regarding the legal stuff, I tend to shy away from it because it's just not helpful. And the family is going through um the family's going through things that can't be imagined unless you've been there. And even then, when you go through it, you can't imagine how deeply painful it is. So I think the Petito family, I'm looking at how they're engaging on social and trying to keep Gabby's name out there and keep Brian Laundarie's face out there so that if people see something, they say something. If you see something, get a license plate, use your phone. If you're in that area and see something that seems sus, it's always better to make a call than not. And that's that. We've got to move on to other things because I've been talking about this for way too long, and it is just time. So thank you all for understanding. I know a lot of you have asked me to cover it more, and I have shared why I just don't feel great about it. Jessica, we were just talking about you. And I said it right just because I know you. So thank you for educating me on how to say things properly. I pronounce literally everything wrong. Let's talk about Scarlett Johansson real quick. Have you guys seen this Scarlett Johansson lawsuit with Disney? Yeah, it's settled. What? Let's talk about that. I got to swoop. I got to write down timestamps and swoop. We're doing two things at once here. Yes, we covered the Scarlett Johansson Disney lawsuit. It was roughly regarding the fact that Scarlett Johansson said that Disney didn't renegotiate with her for streaming monies to count towards box office when they released Black Widow, not in a full theatrical release, but also a release on Disney Plus. So you could watch, which my family and I did, you could watch Black Widow from home when you have Disney Plus subscription and pay like the $30 or whatever it is to get it at home. When Disney answered the lawsuit, well, they didn't really answer it. When Disney filed a motion to have the lawsuit sent to mediation per the agreement, what Disney said was that they actually were counting those amounts towards the box office. And you know what? We're never going to know. Sorry, my voice is still rough. We're never going to know. You know why we're never going to know? Because it's settled. So Scarlett Johansson's team and Disney's legal team both provided statements to Law 360. Both indicated that the issue resolved. And the legal team for Scarlett Johansson said, quote, "I am happy to have resolved our differences with Disney. I'm incredibly proud of the work we've done together over the years and have greatly enjoyed my creative relationship with the team. I look forward to continuing our collaboration in years to come." Let's see what happens with Black Widow's character after this lawsuit. We'll see how petty Disney gets about this whole thing. Disney Studios said that they were pleased that the parties reached a mutual agreement, and Disney Studios content chair Alan Bergman said, "We appreciate her," referring to Scarlett Johansson, "her contributions to the Marvel Cinematic Universe and look forward to working together on a number of upcoming projects." So it is resolved. You know what's going to happen? We're not going to hear any more about it. You know why? It's a settlement agreement. Once everyone says we settle, most settlement agreements, um, most settlement agreements are silent after that. You're allowed to say that you settled, and after that, you are not allowed to say what caused the settlement, the nature of the settlement, the terms of the settlement. Settlement statements are normally mutually agreed upon between the parties. It's like, hey, this is our statement, this is their statement. And then you will hear nothing. And that's generally the way. Now, we don't always see that play out on the internet, but generally settlement agreements have a NDA where you cannot talk about why it was settled, how, what factors played in, any of that. So all we have to go on is what we saw in the court documents. I have not seen a settlement or a motion to dismiss yet in court. I'm sure they are still fine lining out this settlement agreement, but they already released that. All of you who are saying Black Widow is dead, look, man, Jennifer Moss hit the nail right on the head. She's dead in that timeline. Who knows what's to come in the multiverse? We are living in a multiverse MCU, so we can still see lots of Black Widow to come. So I think we might see Natasha Romanoff in alternative timelines for sure. So anyway, settled. Yay, settlement. Didn't I say this? Didn't I say this at the beginning? I need to go back and watch my first video on this when I said this isn't going to go to trial. This is going to settle because accurate. Do you guys want to hear a little bit about what's going on with R. Kelly? We're going to just talk about it briefly. Look. We're going to talk about it real quick. Look, I think R. Kelly sucks too. We are not going to harass or name call and all the things because we're law nerds and we don't do that, even though it's hard when we talk about people that we are like, we don't love. All right, let us talk real quick about the R. Kelly trial. R. Kelly was convicted of 8 counts of sex trafficking and 1 count of racketeering. I thought the racketeering charges were quite clever. Look, RICO can be used for a lot of stuff. I was very interested to see the way that they used it in this trial. I'm not going to get into all of the nitty gritty of this. If you guys are interested in that, I'll do an Emily Show episode on it, breaking down the charges, breaking down what he's still facing, if that's helpful. Today, he's just in the quick bits because, look, we've talked about R. Kelly enough. Like, let's just let him fade away in prison. But he's convicted. He's going to be sentenced on May 4th. However, he's still facing a trial in Chicago for CP and obstruction of justice, and he still has cases in both Minnesota and Illinois. So there is still a lot of legal to come with regard to R. Kelly and with regard to these allegations. Somebody is asking, what does racketeering mean? So RICO is a racketeering and organized crime act that allows you to use all kinds of underlying predicate act to show that there was like a criminal organization. It's kind of like conspiracy, but not, if I can lay it down. And you have predicate acts. So they found that they did a lot of different acts in as part of the criminal organization, and they used the criminal organization, in this case being his, essentially his music career. Like, he was using his team to collect women when he was traveling. Well, women, not all women, some girls, because minors, to persuade them to pay them to do all the things that he was doing. But they charged the organization as his music career. So it was a very interesting way to use RICO. And, you know, organized crime, most of us think of like gangs or the mob, depending on what coast you live on. But it can be other types of organizations. And I see you guys in the chat asking if this is what's going to happen for team conservatorship. I mean, there's a lot of organizations there, and if they were doing things that could be predicate acts, then there could possibly be RICO charges. RICO charges are flexible, like conspiracy. There's a lot of federal crimes that give federal prosecutors a lot of options. So with regard to R. Kelly, there were a few of the predicate counts that he was not convicted on, but those don't really matter. They brought everything in. They only had to convict him of a very, very few to show the proper amount of predicate acts, and ended up showing like 14, I think, of the 16 predicate acts. So the government didn't back down. I'm not surprised. I'm not surprised he was convicted. I'm surprised it took so long, but that's what's happening with R. Kelly. So sentencing is scheduled for May. I saw a number of you ask why the sentencing takes so long. There are going to be reports that are done. There are going to be motions that are filed by the government, motions that are filed by the defense. So there's a lot of legal work that goes into running up to a sentencing. So that gives adequate time for that legal work to happen. And this is the federal case. But even in state court, it's very rare that a conviction comes down and it's like, hey, the jury comes in, the jury has a verdict, the jury reads the verdict. You know, I sat there a lot, sitting there waiting for a jury verdict, by the way, literally one of the craziest feelings on earth. I don't know. I can't liken it to anything in my life. Look, I played Division I water polo in college. I would definitely get nervous before games, but it wasn't the same as sitting at counsel table as a jury files in and you know they have a verdict and you're sitting there waiting to hear what they say. I don't know what that's like for a defendant, but I know what that's like for a prosecutor. It's a very specific and unique type of anticipation, and it's odd. Anyway, so when a jury comes in and they hand it to the bailiff, and the bailiff looks at it and the judge looks at it and makes sure that they haven't done anything wonky. There's times that jury verdicts have to go back because they didn't sign a thing. Worst ever, by the way, when it's like, you didn't sign this and this and that. Fantastic. So you get the sentence, they read it, and then they will either, if the defendant's not in custody, they will often take them into custody. If they're in custody, they will take them back. And then the jury will be escorted out of the courtroom. The lawyers will have an opportunity to interview the jury if they need to, and then come back in and set a sentencing date. I've never seen a case where it's like, okay, and your sentencing is this. Like on probation violations, yes, but not after trial. It's always set over for later because there's always more legal work to do before a sentencing. Hopefully that makes sense. Sorry to wander. Sorry to wander with my explanation. I see the chat is saying Natalie Lawyer Chick has a great R. Kelly video. Natalie Lawyer Chick is fantastic. I love the way she thinks. So if I haven't seen it yet, but I trust the chat when they say Natalie Lawyer Chick has a video on it, it is going to be excellent because she is excellent. All right, let's continue. Elizabeth Holmes trial, you guys. There's a lot happening. We're 4 weeks in. Can you believe it? We are 4 weeks in to the Elizabeth Holmes Theranos trial. What? I know, I can't believe it either. So, also people were cosplaying. I'm still not over that people were cosplaying as Elizabeth Holmes at her trial. People showed up dressed as her. But here's the thing. Okay, so real quick. If you guys don't know who Peter McKinnon is, he's a YouTuber, photographer, storyteller. He's a very entertaining human. He's very, very tall in person. Look, I'm sure people were thinking when they met me in person, they're like, she is fluffier and shorter than I anticipated. Yes, but most of the male YouTubers I met, I'm like, oh, you are taller than I expected you to be. Peter McKinnon being very, very tall. But after he finished talking, all these guys who wanted to go talk to him, you know, when a speaker gets off stage and everybody goes to the side of the stage because they want to catch them, all the guys that went to go talk to Peter McKinnon were dressed in head to toe black, just like Peter McKinnon. I'm like, this is fantastic. Like, there were people cosplaying as Peter McKinnon, watching Peter McKinnon speak. Oh, Natalie, thank you so much. I'm so glad you caught this on your lunch break. It's so good to see you. We were just saying wonderful things about your R. Kelly video, and I'm telling everyone that they need to go watch it because we are just doing it in quick bits. So that is what it is. But for the Holmes trial, we're now going into week 4. We have heard from former General Mattis, who was also like Secretary of State or Secretary of Defense and all the things. He testified, which I wasn't sure we would get board members testifying. So now you have a very well-respected board member testifying and really saying that he was kind of taken in with all of the Theranos, one drop of blood, don't say goodbye too soon, all of the Elizabeth Holmes myth and legend. I'm 19. I've created this thing. Well, you haven't. So it was interesting hearing him say, even as a board member, he felt misled. You also had the lab chief testifying about the things that were going on in the lab. So some really, really interesting testimony with regard to Mattis testifying. He said, I thought all along we were doing the tests on Theranos gear and I was a member of the board. So going into the everyone being misled, it's going to be very interesting to see how this all plays out. They also had a woman testify who had been going through a pregnancy and got wrong lab results that might indicate a miscarriage, but she had already suffered miscarriages, which to anyone who's been pregnant and has or has not worried about pregnancies can be very, very triggering when you have to check your levels and then those labs come back wonky. So without getting into the emotional side of it, the jury got to see the real world implications and the real humans that were hurt by this tech and by the lies around this tech and by the fact that they were running human person blood samples for consumers on equipment that couldn't do what they said it could do. And it was just wild. So the jury has heard a lot. I will be very interested to see when we get to the defense case what they bring out. We've also seen quite a lot of text messages between her and Sonny that I think will go against um, her defense. But her defense team, I mean, she has a good defense team. Her defense team is going to decide how they bring their defense at the end of the government's evidence because it is their job to bring in reasonable doubt, and they will decide how they're going to do that as the trial unfolds. You might have a rough idea of like, we're going to point to these things, but that notion will continue to get solidified as the prosecution's trial, as the prosecution's case in chief continues. I will be very interested to see. I'm interested to see now how it's going, but I will be very interested to see that. We're going to probably be getting into some of the nuts and bolts of the scientific-y stuff, which is a little boring for jurors. But if they pepper it in with the human element and with the whistleblowers, that stuff tends to be a little more juicy. And I think jurors will be riveted by that testimony. And we've already seen some of that. So 4 weeks in, we got a long way to go. They're not expecting this to go to jury till December. So we got a lot of boring ass testimony coming up in the Theranos trial. I'm seeing a number of you saying it's your first live. If today is your first live, go ahead and drop a 1 in the chat. It's so good to see you. We are just finishing up quick bits. We're getting into Tati, and then we are going to get into all of the Britney's updates. We have one very big minute order to go over and then a few other things. There's a new objection from Britney's team that I haven't covered yet. It's so many of you guys, all of you new, go ahead and subscribe, first of all. Do the likey, subscribey things. I'm supposed to remind you. I forget literally all the time because I'm so happy sitting here talking to the law nerds that I forget to do the things. I forget all the time to do the things. It's so good to see all of you. I talked about all of you at Vid Summit. Okay, we're going to talk about that later. All right. So many new law nerds. Welcome, welcome, welcome. I'm sure some of you listened to the Juicy Scoop this morning, and I'm glad for you finding me here. We'll talk about that in Q&A. We have to move on to Tati updates. Are you guys ready to talk about Tati updates? Are you ready? Are you ready? Yes, I'm ready too. All right, y'all. We have been covering the Tati Westbrook legal cases for, well, almost a year now. It's October. This all popped off at the end of October. So we're coming up on a year of coverage, which for Tati Westbrook herself has to be exhausting. And I think we saw that a lot of you messaged me about her last video where she kind of alluded to the where of the amount of lawsuits going on. It's exhausting. I'm sure that these lawsuits have absolutely changed her life. But the thing is, the ongoing lawsuits right now with her business partner, this is someone who was friends with her husband. So all of these suits going on now are involving Clark Swanson, who was a friend of her husband. There's a different type of betrayal there when it's somebody that you knew and trusted and brought into your business. And I'm sure that Swanson feels that way too. Who knows? He clearly seems to feel betrayed. He filed 2 lawsuits against the Westbrooks. They filed 1 against him. Some of these Westbrook lawsuits are also regarding the business. So not all of them are just the Westbrooks and Swanson. Some of them are Halo Beauty and Halo Beauty. They had a big hearing at the end of September in court, and the judge ruled in favor of the Westbrooks with regard to moving the case to Nevada. I actually am really interested to go through this minute order with you all. So let's go ahead and pull it up because of course screen share is ready to go because we're professionals here. Look, I haven't streamed in like a week. And it all just gets wild. So here we go. Did I remember to swoosh? I hope so. Let's go ahead and talk about this case. I'm fascinated by this case. Just look, as I sidebar myself, road so far. If you guys haven't followed the depth of the Tati Westbrook cases, currently there are 3. There is the OG business partner lawsuit that started it all. This business partner lawsuit started with, this is a lawsuit because of the defendant's greed. Remember that? That's how this lawsuit started. Oh, you guys are telling me I forgot to swoosh. Okay. Darn it. That means I forgot to timestamp. We're swishing. We're swooshing. We're swooshing. Tati Westbrook has a lot of lawsuits. We've swooshed. We're professionals, people. There are 3 lawsuits. The OG business partner lawsuit. This is a lawsuit because of the defendant's greed, where there was shade thrown at Tati and allegations from her business partner that she was just slinging shit to her subscribers because she could, and that James Charles and Jeffree Star were going to promote her vitamins, and that she had this dinner with Manu Amiwe and Laura Lee, and it feels like reading the lawsuit. It's like, oh, 2017, what summer children we all were. Winter is coming. It was so funny, but it had a lot of shade. I mean, allegations and shade in that lawsuit, lots of it. But the Westbrooks live in Washington State, which has been made clear. Clark Swanson lives in Nevada. The business, the operating company, the amount of companies we're dealing with is a lot, but the overall operating company moved to Nevada. There is a holding company that was reorganized in California and reorganized into the Nevada company. There is a company that Tati owns in Washington that owns part of her shares. There is no California company. So when we got this lawsuit, and then we got the defamation suit that I'm sure you all remember between Tati Westbrook and KJ. When that defamation suit happened, there was a motion to dismiss for murderous conspiracy. No, it was a motion to dismiss for lack of personal jurisdiction in the state of Washington that was granted. And then in this business partner suit, Tati's team filed a motion to dismiss for form nonconvenience and a motion to kind of move the case from California to Nevada, saying, hey, there's nobody here in California. Why should we have this case here in California? Then it seems that Clark Swanson next sued the Westbrooks, like on a personal level, for defamation. We talked about that when I got the letter of cease and desist. That is in Washington State, where the Westbrooks live. What we got for allegations in the California suit, the OG suit, was like, but when I filed this, I thought the Westbrooks lived here. But what we know from other lawsuits is that Clark Swanson was the one who filed the change of address for the Westbrooks when he reorganized the companies. So we saw that alleged in other legal documents saying, hey, but you did this, you know that they moved. Then the Westbrooks, on behalf of their companies, sued Clark Swanson in Nevada for essentially for a whole bunch of shit, including talking to KJ about the Westbrooks allegations, which Clark Swanson denies, allegations that we saw kind of fleshed out when we learned that the Westbrook defamation suit from Washington had settled, that it was like, I got all this information from this person over here. Clark Swanson said, both through his lawyer letter to me and in other filings, that he did not talk to KJ the entire time she made statements, that some of those statements were made before they ever had communication. And he actually reached out to her because she was already essentially talking shit about the Westbrooks. So the lawsuit in Nevada is dealing with fiduciary responsibilities, duties to the company, and trying to force Clark Swanson now in the legal filings that are happening to turn over access to the company books. Taxes are due, all of this stuff. That is going on while the California case is going on and while the defamation case is going on. 3 cases. It's a lot. Let's get into the ruling in the California case that when it was filed, all of us were like, hey, what's going on in this case? So I don't know if my mic went out. That wouldn't be good. We'll double check it. It seems like it says it's fine. It says it's all good. So hopefully you guys can hear. Let's get into this. When this was filed, all of us are like, is this going to get yeeted to Nevada? It was my speculation that this would in fact get yeeted to Nevada. That was my thought. So let's get into what the court had to say. Nature of proceedings, ruling on submitted matter. This was from the September 24th hearing. There are no appearances, or the September 21st hearing. There are no appearances because this is the judge making a ruling via a minute order. A minute order is just an order from the court. They are just like, hey, this is what I did. It goes on the record, blah, blah, blah. So this is the ruling of something taken under submission. A matter taken under submission means the court hears the parties and says, hey, I heard what all y'all had to say. I need to think about it. I'm going to take it under submission, and then I will issue a ruling at a later time. So the court took this under submission at the hearing date, which we talked about on that date because there wasn't a minute order yet. And I'm like, there was a hearing today. We don't know what happened yet. Nature of proceedings, ruling on submitted matter. The court having taken the matter under submission on 9/21 for hearing on motion to dismiss or stay action, CMC now rules as follows. Final ruling. Defendants Tatiana Westbrook, James Westbrook, Halo Beauty Partners LLC, Halo Beauty Inc., Tati Halo Inc., and Tati Cosmetic Inc.'s motion to dismiss or stay action for form nonconvenience is granted. Plaintiffs Clark Swanson and Swanson Global Inc.'s action is hereby stayed. What that means is that the action is now TO'd. Time out. Stop. Stop right now. Thank you very much. I didn't mean to punch my microphone, and I really hope it wasn't loud. It stayed. Nothing else is happening in this matter. The clock isn't ticking. Everything is just frozen. I'm not going to sing Let It Go. There's no way that's happening. But that's exactly what crossed my brain. So it stayed. An OSC redismissal is set for December 17th, 2021 at 9:00 a.m. What that means is that they anticipate, and I'll get through the reasoning in a minute, they anticipate that Swanson and Swanson Global will take this lawsuit into Nevada and file it there. And once it's filed over there, this one will be dismissed because it's not going to go forward. So that should all happen before December 17th. They will have an order to show cause with regard to why the case shouldn't be dismissed. If Swanson has not filed that suit in Nevada by that time, the court is going to want to know the fuck why. Why haven't you? I don't care. I'm dismissing it. So the court is leaving it stayed here probably for concern of statute of limitations and just so that the court can make sure that it gets done. But let's see what the court's reasoning is. Defendants Tati Westbrook to give notice, which means the legal team for Tati will have to give notice. In this one, it is not Saltsy. I am sure he is part of the legal team in this, but this is being defended by our friend Doug Fuchs. And by friend, I mean, we like to say his last name Fuchs instead of Fuchs, and I'm sure he sincerely appreciates it, seeing that he is a well-respected lawyer at a very high-profile firm. It's with peace and love, Doug. Your last name could go either way. Reasoning. Plaintiffs Clark Swanson and Swanson Global requested judicial notice of two court records, 3 corporate documents, 1 record from the U.S. PTO, and 2 corporate documents filed by with the Nevada Secretary of State's office. Plaintiff's request is granted. So all of the things that they wanted the court to take judicial notice of, they did. Notice that what they're taking judicial notice of is U.S. Patent and Trademark Office records, California Secretary of State records, corporate records, court records, and corporate documents, not YouTube videos of Trisha Paytas saying that she thinks Tati is dumb as hell. And if you've been around this channel for a while, you know why that's a reference to a request for judicial notice. It was the request for judicial notice that brought us motley crew of gossips building monuments to the gods of speculation. That came in a response to a request for judicial notice, wherein judicial notice was required to be taken of a Shane Dawson video, of a Trisha Paytas video, of other videos in another related lawsuit, not related anymore. Analysis. Defendants Tati et al. Move the court for an order dismissing or staying the present action on the ground that this action should be litigated in Nevada. As both plaintiffs are Nevada residents and they bring claims derivatively on behalf of 2 Nevada business entities against the directors and officers of those companies pursuant to Nevada corporate law, which means the law that applies is Nevada law. Plaintiffs are Nevada residents. They're bringing the claims on behalf of the company, also Nevada residents. Spot the Californian in this as I read through this. Defendants argue no party in this action resides in California. Only one single defunct defendant, Halo Beauty Inc., is a California corporation, and that entity has no assets and no interest in this suit and is an empty shell company whose assets were transferred into a Nevada corporation, also named Defendant Halo Beauty Inc. Defendants further contend witnesses reside in Nevada, corporate records are in Nevada. A Nevada court has an interest in derivative claims governed by Nevada law, brought by a Nevada citizen on behalf of a Nevada companies, and a Nevada court can better analyze and apply the complexities of Nevada law governing fiduciary duties and corporate responsibilities at issue in this action. Ugh. How many times can the court say Nevada? You can see why they granted this motion. The court is like, let me tell you how much I think this is in Nevada. Nevada, 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 Nevada. The court made it clear. Plaintiffs oppose this motion on grounds that the alleged fraud occurred in Los Angeles County and was perpetrated by people who were then Los Angeles residents upon other then Los Angeles residents. They then go on to quote, form nonconvenience is an equitable doctrine invoking the discretionary power of the court to decline to exercise jurisdiction it has over transitory causes of action when it believes that the action may be more appropriately or justly tried elsewhere. Right. Nevada law applies to Nevada companies with Nevada residents. Why the fuck does a California judge care? And why would California spend the money to litigate this suit? Ashley's Pretty Little Life, California, she doesn't even go here. Yes. When a court or motion of a party or its own motion finds that it is in the interest of substantial justice, an action should be heard in a forum outside of that state. The court shall stay or dismiss the action in whole or in part on any conditions that may be just. The court goes on to cite a bit more law that says the exact same thing. In determining whether to grant a motion based on form nonconvenience, a court must first determine whether the alternate form is a suitable place for trial. If it is, the next step is to consider the private interests of the litigants and the interest of the public in retaining the action for trial in California. The private interest factors are those that make trial and the enforceability of the ensuing judgment expeditious and relatively inexpensive, including 1, ease of access to sources of proof, evidence, witnesses, documents, etc. 2, the cost of obtaining attendance of witnesses, which is going to be hard during COVID to bring people from out of state. 3, because then, look, you have to subpoena people. So you have to subpoena witnesses to court, whether they're cooperative or not. The court has to issue subpoenas to bring witnesses to court. If all the witnesses are out of state, the court has to do a whole lot more shit to extend its jurisdiction and have the Nevada court say, yes, we will honor this subpoena for Nevada residents. But if the subpoenas aren't adhered to, you've got to go to Nevada court and be like, they didn't show up on the subpoena. And then you've got to go back to California court and be like, they didn't show up on the subpoena. Like, it's a giant pain in the ass. And that's where the jurisdictionality of the things matters so much. So when the court says the ease of access to sources of proof, that becomes a very big factor. The cost of obtaining attendance of witnesses. I illustrated a small fraction of the problems that can happen. The availability of compulsory process for attendance of unwilling witnesses. Again, how do you drag a witness from Nevada to California under a Nevada subpoena? Yep. The public interest factors include avoidance of overburdening local courts with congested calendars. California's calendars are some of the most congested I've ever seen, especially in civil. 2, protecting the interests of potential jurors so they're not called upon to decide cases in which the local community has little concern. California jurors. I'm sorry, Nevada residents, Nevada company, Nevada law. I live in California. Like, I spend a lot of time in Nevada because it's close. You could drive to Vegas. There's a Sheryl Crow song about it, but I don't give a fuck what's going on with these Nevada companies. 3, weighing the competing interests of California and the alternative jurisdiction in the litigation. The moving party bears the burden of proof on the motion for form nonconvenience. While a California resident plaintiff enjoys a strong presumption in favor of plaintiff's choice of form, a non-resident plaintiff's choice of form is entitled to due deference under circumstances, but not strong presumption. Those are different standards. Due deference and strong presumption are different standards. Yes, this is why you go to law school, so that you can fight over the level of proof between due deference and strong presumption. It's like due deference is here, but like I'm up here. strong presumption would be up here. It's like Kelly Ben Simone trying to explain to Bethany where she fell. Due deference being here, strong presumption being here, and the two do not mix. So because Swanson is not in California and because the companies are not in California, they only get due deference. So the court first considers whether the alternate form, Nevada, is a suitable place for trial. As to whether Nevada is a suitable place for trial, plaintiff Clark Swanson is a Nevada resident. Plaintiff Swanson Global is a Nevada corporation. While plaintiffs allege defendants Tati and James Westbrook are Los Angeles residents, defendants provide sworn statements that they are residents of the state of Washington. So why that matters, the shade of it all. The court just said in this minute order that Swanson has contradicted himself. Plaintiffs allege that defendants Tati and James Westbrook are Los Angeles residents, but defendants have proven that they are residents of Washington, and plaintiffs concede that the Westbrooks currently reside outside of California in Washington. I think at the time that this was sworn, Swanson was aware that they had moved, but that is based on all of the other litigation that we have seen. Two corporate defendants, Tati Halo Inc. and Tati Cosmetics, are incorporated in Washington. The corporate derivative, for those of you that have not heard me wax on about derivative claims, this is not a business associations lecture, but suing derivatively means that one member of the board or one person or group of persons are suing on behalf of the company, but they're also suing the company. So it is complex. We've talked about it in other videos, but when they're talking about the derivative defendant is suing itself. So Swanson is suing on behalf of the company to make members of the company do a thing that he thinks they should have done. In this case, sell the neutrals palette from Tati Beauty under Halo, not under her own company. It's the heart of the thing. The corporate derivative defendant, Halo Beauty Partners, is a Nevada LLC. Plaintiffs allege that Halo Beauty Inc. is a California corporation and a Nevada corporation in the complaint, but defendants represent that the California entity exists in name only and has no interest in this litigation, as it moved to Nevada in 2018 for tax purposes. Plaintiffs represent that only that Halo Beauty Inc. was a California corporation at the time the events and issues occurred, but it appears plaintiffs acknowledge that the Nevada entity of Halo Beauty Inc. is the only active of the two. But if not, the court finds it so. The court's like, even if you didn't say that, I'm finding that it is an active Nevada corporation. This is a long ass minute order. Look at this. I'm going to have to move faster because we've got lots of Britney shit to talk about. Okay. I'm going to swoop. I'm fast. I love the judge's writing so much that I'm just kind of sucked into all of the tea. I'm going to try to quickly move to the hot tea and not bore you all with the law of derivative litigation in a form nonconvenience. I just so like this minute order. It's just such a well-written opinion. I like it. They then go on to say that insofar as plaintiffs contend Halo Beauty Inc. is not subject to jurisdiction in Nevada, such that Nevada is an inappropriate form. Again, defendants present evidence that the Nevada entity owns and operates the nutraceutical business underlying the dispute. The California entity has no ownership stake in the interest. Indeed, plaintiffs acknowledge in their verified complaint, plaintiffs acknowledge in their verified complaint executed under penalty of perjury by plaintiff Clark Swanson that, quote, Halo Beauty Inc. underwent an F reorganization into a Nevada corporation on or about May 23rd, 2019, when it was incorporated in the state of Nevada. It's in the complaint. And the court's like, it's in the complaint. In the complaint, you say that the only California entity is not a California entity. It's a Nevada entity. Why the fuck are we here? But instead of just saying that, the court went through extensive analysis as to why the fuck we're not going to be here anymore. They go on to say plaintiff's representation that the California entity is a member of Halo Beauties Inc. is not well taken. That's about the most judge shade you're going to get. The point is not well taken. That is Judge Sass. We got some Judge Shade and some Judge Sass. He's like, I don't buy it. The only proof is from December 28th, 2018, 2 years before this action was filed. Furthermore, plaintiffs concede in their opposition that this action is not a complex derivative case as suggested by the complaint, but rather merely a business dispute involving alleged fraud perpetrated on the individual plaintiff by the individual defendants. Oh, interesting. So what the court is saying is that Swanson admits or concedes in their opposition to this motion that this, Your Honor, we don't need to go to those special business courts in Nevada. This really isn't like a super deep derivative case, though they proceeded as if it was a derivative case with giving notice and all the things. But really, it's just a case governed by the defendant's greed. See, it's really that I, Swanson, want Tati and James Westbrook to pay me for whatever they earned from the Tati Beauty palette. See, it's not really derivative. It's really just about a makeup palette. They really just defrauded me. It's about me. The court's like, okay, well, you are in Nevada, so go. Given this concession and in light of the fact that the California Halo Beauty has no interest in this action, the court finds that Nevada is the suitable place for trial. They then go on to consider the private interest in litigation. California doesn't know you. You don't even go here. We don't know her. We don't care. The court takes care to note, oh dear, what is the court taking care to note? I want to know. I should just ask. I will ask. I want to know why they didn't just file it in Nevada in the first place. Like, why pick here? I don't understand the strategy in it. There's normally strategy in it. Were they going to try to speculation incoming? Speculation, not fact. Emily, speculation. People tend to watch the LA Superior Court filings more than they watch other places, like the business courts in Nevada. Unless you think something's happening there, why would you even pay attention? Was it filed in LA to try to get eyes on it? But there's allegations in the other lawsuit that Swanson gave this suit to KJ, gave the complaint to KJ and was like, you should cover this. Like, he was promoting this suit in the media, which is alleged in the other lawsuit. So even if you're going to blast it, it doesn't matter what court you file it in. If you're going to be like, look at what we're doing, this person's been sued, here are the court documents, then why bother? I mean, it's not like you file it in California hoping somebody will stumble across it if you actively promoted it as is alleged. And we know based on other coverage that KJ had this complaint before it hit the online filing system. So if you're going to do that, then I don't think picking form based on potential publicity makes sense. So I don't know why pick California. I don't know. I don't know why pick California on this one, because it seems that it is a lot of litigation with not a lot of payoff. I mean, it wasn't as much litigation as the KJ suit, truth, because there were only some filings on this. So, all right. The court takes care to note that plaintiffs filed a first amended complaint the day before the hearing on the present motion. Oh, shit. Why? Why file a FAQ? Get your FAQ out of my suit. Why file a first amended complaint the day before this? This motion has, look, this suit was filed last October, and it was coming to hearing almost a year later. So this has been like pending 9 months from the time that Tati's side filed this motion to dismiss. In 9 months, you wait until the day before the hearing to file a first amended complaint? Come on. Wherein plaintiffs allege the newly named defendant, TB Co. LLC, and that TB Co. LLC has its principal place of business in Ventura County, California. Who's TB Co. LLC? Does that have to do with Tati's makeup? Hold on. We're going to Google real quick. Because now I'm curious. TB Co. LLC. Who is TB Co. LLC? No, probably not that. TB Co. LLC, California. I should just pull the fact because now I'm curious. Oxnard Company, let's see. Makeup. Is this the parent company of Seed Beauty? Is that what this is? I think this is the parent company of the company that did this for her. So the parent company of whoever did the Tati Beauty stuff. Okay, we're just going to keep reading, but I was curious. All right. Sorry, we're going to keep reading. Y'all are like, keep reading. I do that all the time. Keep reading, keep reading. Defendants object to the filing of the FAC as untimely. Truth, given the pendency of this motion, whether the filing of the of an FAC while a motion to dismiss or stay for form nonconvenience is pending as appropriate is not before the court. The issue has not been briefed, and the FAC was just filed. Regardless, the basis for potential liability of TB Co. LLC for the conduct at issue in this action is unclear. Plaintiffs allege only that TB Co. LLC is one of the business entities used to launch Tati Beauty color makeup palette. So whoever Tati made the palette with, whoever the formulator was then, would be under TB Co. LLC. I think she used Seed Beauty, but I'll have to look later. We'll answer this question on the Twitters. If you don't follow me there at the Emily D. Baker or Instagram at the Emily D. Baker, we'll cover it on social. We need to move on to Britney, so we're gonna move quickly. Further, the new entity was not mentioned in the opposition papers. Plaintiffs did not move ex parte to continue the hearing based on the present motion. So they're trying to loop in somebody else to try to make it fit in California. Accordingly, the court finds the interests of substantial justice mandate that this action be heard in Nevada. The court's mindful of its power to dismiss an action for form nonconvenience is more limited than its power to stay in action. However, the exceptional case which justifies the dismissal of a suit under the doctrine of form nonconvenience is one which California cannot provide an adequate form or has no interest in doing so. That includes this. For these reasons, defendant's motion to dismiss or stay is granted. Plaintiffs is stayed. OSC redismissal December 17th. They went through the evidentiary objections and the final ruling. So that's it. Everything's going to end up in Nevada. This will probably end up this will end up looped in to the other case that Tati has filed. So anyway, we will see. Somebody's asking, is TB Co. Tati Beauty color? We're going to have to look into it. I will pull it and figure it out and answer on social media. I didn't pull it before this because I was busy trying to pull all of the vast amount of minute orders in the Britney Spears case. It's time to talk about Britney. It's Britney, bitch. We need to do that. Because all of you, if you guys are here for Britney, just pop purple hearts or pink hearts for Britney. Pop pink hearts down in the chat and let's get into talking about Britney's big win in court. I mean, that was a pretty big win for Tati too. She got the case yeeted so it can all be heard in the business courts. And I don't think the business courts are going to appreciate some of the ancillary fuckery that's been going on in the business partner lawsuit. So I think it's a win for Tati. I see it as a win. Britney Spears gets rid of her father. The motion to yeet was granted. I am excited. Look, the more I've covered this case, the more invested in this case I have become. Like all of you are with me. I am invested. I know that there have been so many covering this for years. When I talked to Caleb Marshall, the fitness marshal, did you guys see him go viral over his reaction? I'm going to have to play it. Did you guys see that? We're going to talk about Caleb for a minute. Hold on. Because I love him. I love his team. I love everything about it. And his short, it's not a short, reel. His reel or his TikTok, they were the same, went completely viral over this. Let me pull up his Instagram so I can show you. But this response is just the greatest response ever. He was absolutely everywhere with it. I love it so much. If you guys haven't seen it, well, you're going to get to see it now because I'm going to share it because I want to. Because it's the energy we need to bring in to this moment to talk about Britney. That's just what it is. So the audio should be shared. Let's go to Caleb going completely viral over this.
Is there a quick update or am I gonna get mad?
Hold on. I want to make sure we're at the beginning of it. Hopefully you guys can hear it.
Is there a quick update or am I gonna get mad? Jamie's gone?
Ah! I clicked. I'm terrible at this. There we go.
Is there a quick update or am I gonna get mad? Jamie's gone? Sorry. Jamie's gone?
Kayla. It pulled out how?
Of the conservatorship?
Me.
Woo! Oh, this is a good day. We're gonna sweat booties.
Me when I was
Free Britney. In, out, throw. A reason. You just gave me a reason.
I love it.
My queen is one step closer to freedom.
Get it.
We are gonna slay this so hard in the name of Britney James Spears.
All right, I'm gonna turn the volume down so I don't get music.
Jump high, knee, Jamie in the face. Yes, elbow him.
Love it. Love
in
it.
the name
love
of the
it.
law. Reach high.
Love.
Elbow for freedom.
Love Caleb. Did you guys see that Sam Ashgari, Britney's fiance, commented on that? It was amazing. Hold on, let me see because I accidentally closed this window. What the comment was from Sam. We'll bring it back up. Anyway, I loved everything about it. I feel you guys. You guys feel it. We all have felt it, right? So let me just pull up. If you guys haven't seen it, I will link it down below. If you guys don't follow the Fitness Marshal here on YouTube, he is a fitness pop star. He's amazing. I just love him. So let me see on volume silent, pull this up with what Sam said. It's fantastic. We've got to go back to share screen again. I know we're professionals, people. We're professionals. I love Caleb too. I think he's great. This is the type of energy I'm talking about. Like, come on. What a day. This went viral on Instagram. This went viral on TikTok. Absolutely the energy I was loving. I'm so happy. A, I'm so happy for him. He's an incredible creator. And B, I'm so happy to see those who have been following this. And Caleb and I have DM'd and talked about it. He's been following this since it happened. And there are so many out there that have been following this since it happened that the judge finally ruling in Britney's favor felt like a huge weight had been lifted from everyone. So this is I freaked out on Instagram. Then I came over to YouTube and did a live where I continued to freak out. Now we're going to talk about the facts a little bit because I have reined myself in mildly. So if you guys want to see the whole thing, I will link the Fitness Marshal. Go follow him on whatever your preferred platform is. He does workouts here on YouTube. He does great content on both TikTok and Instagram. Love. Can't say enough. Love his whole team. Hi, ladies. Love you guys. You're the best. I like the dark hair. It's good. I like it. I like the dark side. Anyway, back to talking about Britney. So Britney was in court on September 29th. I was not even cautiously optimistic. I was nervous that the judge would not rule in favor. This was absolutely fought out in court. Britney Law Army on Twitter was doing the heavy lifting to bring information out of court. And that's what I covered on my reaction and on Instagram, was the back and forth that happened between the lawyers. When we can get a transcript from this, if it is publicly available, I will order and pay for a transcript. I'm putting it out there now. I am ordering and paying for the transcript, and we will spend an entire live stream with drinks dramatically reading the transcript because Rosengart and Vivian Thuren went in to get into this. Okay. So let us get into this of the longest minute orders. There are 4 other minute orders. We're going to go through all of the minute orders that have been released, and I will share these on social later today. This one I just saw today. So this is new. Last night it was not available. So yay. We're coming at something early in the morning. Woo woo. All right, this matter is called for hearing. We need some coffee. This matter is called for hearing. All parties appeared via LA Court Connect except Matthew Rosengart, Lisa McCurdy, and Yasha Bronstein. I hope I said that right. No disrespect when I mispronounce names, Yasha. Matthew Rosengart made a powerful and strategic choice by appearing in court. I think when you are fighting something out like this, you need the judge to look at you in the face. Everyone else was on Court Connect. Let's talk about everyone else that was there. Sam Ingham, he had matters on calendar. Jody Montgomery, conservator of, or temporary conservator of the person. James Spears, no longer conservator of the estate. Lynn Spears, Lorianne Wright, Marie Mondia, I don't know which legal team she's on. Geraldine Weil, Gerald Cohen, Jonathan Park, Vivian Thuren, Yasha, David Nelson, Ronald Pearson, Gladstone Jones, Lynn Swanson, Matthew Rosengart, Lisa McCurdy, Scott Bertstick, Kevin Colley, and Justin Gould. I think Lisa is the one that filed the amicus brief with regard to the motion to dismiss, if I am remembering correctly. So I think appearing in court for Matthew Rosengart, arguing something as important as suspending or yeeting Jamie Spears, you want the court to see you and hear you. Also, it seems from the reporting that Brittany Law Army did that there were times when Rosengart would just cut off Vivian Thuren. And it's really hard when you're the one on Zoom to reestablish your dominance in court when you're just back and forth. So that's what it is. Some of you are asking, how are people on Zoom? This top list is just a list of everyone that's present. And then this is just a note of who was in person. And Justin Gould also. I didn't see that name at the end. The court takes testimony after argument by counsel. The court overrules the objections filed on September 27th and rules as followed. The court suspends James P. Spears as conservator of the estate of Britney Spears and appoints John Zabel as temporary successor conservator of the estate. It didn't feel real to me until seeing it in this minute order. This is official. This is officially it. Yes. It's official. It's in the minute order. Like we heard it happen, but it is in writing. I'm going to clip that. I'm going to share this. I will make this link available. If any of you want to frame this minute order, like I will not judge you. I will put this up on Twitter when I'm done with this at the Emily D. Baker. I will make a link. So if you want to download this minute order for posterity, I will make it available to all of you. And I'll put a link down in the description here too. Everyone deserves access to the fact that this finally fucking happened after years and years and years of Britney asking for her dad to be removed. Britney tried at the beginning of the conservatorship to say anyone but him. For 13 years, she has been trying to get her dad out of this conservatorship. And even at the beginning of the conservatorship, it was just not him. The fact that this went on so long, look, we're not going to soapbox. We need to get through all of this. The petition to appoint temporary subsequent conservator, which is important, filed on 9/22 by Britney Jean Spears, is granted. John Zabel is appointed as temporary conservator of the estate of Britney Jean Spears until 12/31/21, and temporary letters shall be valid until that date. Meaning they are extending this conservatorship until the end of the year. And at the end of the year, I am hoping that will be the end of this conservatorship. So we won't need to extend this any longer. That's what Matthew Rosengart has indicated in all of the talking points he's done after this court date. And it's what he said in his filing papers. I want this conservatorship done this fall. So seeing those granted till the end of 2021 is a good sign. Yes, they can be extended. However, I'm taking it as a good sign. We need something positive. Justin Gould of Oldman Cooley. Jesus, that's a long firm name. Okay. Justin Gould of Oldman, Cooley, Salas, Breinberg, Coleman, and Gold makes his appearance as counsel for John Zabel. Oh, that's who Justin Gould is. So John Zabel already has his own counsel. We talked about this because Vivian Thoren's counsel for the conservator of the estate, James Spears, is no longer the conservator of the estate, which means the new conservator of the estate, the temporary conservator, has their own counsel, and Vivian Thoren is out, which is very exciting. So Justin Gold, of all of the names, that's a lot of names, appears as counsel for him. The court appoints Zabel the power to temporarily operate at the risk of the estate, a business enterprise constituting an asset of the trust. So these are all the powers being granted now. So this is interesting. So powers being granted: the power to pay, collect, compromise, and otherwise adjust claims, debts, and demands upon the conservatorship. The court grants Zabel, as temporary conservator, the following additional powers. These are the following additional powers are powers that were also granted previously. These are not new. These are just being consistent with what was done previously. All right. A, the power to obtain all documents and records related to the conservatee and her assets, whether held in her name or in the name of another, James Spears. James Spears. Whether held in her name or the name of another, James Spears. All contracts, information relating to credit cards, bank statements, estate planning documents, receivables, and any and all power of attorneys. Turn over the file immediately. The power to take all actions necessary to secure the conservatee's assets. Yes, I have seen stuff going on online that James Spears has been selling property that might have belonged to the estate. The new conservator can look into that and can absolutely put a stop to that, can renegotiate contracts, can pull out of contracts. So we'll see what happens. The power to revoke all powers of attorney, including powers of attorney for making healthcare decisions, managing real estate, and to terminate any and all agencies. To thoroughly and successfully yeet. I'm sorry. I realize I'm like leaning so far into my screen because I'm like, this is my first reading because this just happened this morning. Well, this just became available this morning. All right. The power to commence and maintain litigation and participate in any litigation. This was originally done because it was with regard to the restraining orders and things like that. But this allows for this to continue on and moving forward. So the power to commence and maintain litigation and participate in litigation with respect to which the conservatee is a party or has interest, the power to retain counsel and experts, including someone to write a prenup, and to pay for the same from the conservatorship estate. This is how James was doing a lot of stuff: the power to retain counsel and experts, not only as to the family law case, but for any other matter. That includes getting a prenup done so Britney can get married. The power to perform any and all acts that the conservatee can perform with respect to local state taxes. So this is this is all the payment powers. And taking control of all of the entities. If there are entities, we know that there are entities that have been operating for Britney's business. This is all the stuff that was in the other letters. This is just formally stating them on the record that all of the powers that Dad Spears had have now gone to the new conservatee of the estate. The power to prosecute civil harassment restraining orders deemed to be appropriate. The power and authorization to pursue opportunities related to professional commitments and activities, but not including but not limited to performing, recording, videos, tours, TV shows, other similar activities, as long as they are approved by the conservator of the person and the medical team. This is what caused so many problems early on, is that Dad Spears was also the conservator of the person. So he was negotiating on both sides. He was approved as conservator of the estate to negotiate TV appearances and performances. But the limitation was that the conservator of the person, who's supposed to connect with the medical team, was allowed to approve that and say whether that was something that was actually beneficial to Britney or not. He was in both positions. And then he was negotiating himself a 1.5% cut of that in addition to his salary. And that's where a lot of this is problematic. So The power to select, invest, and monitor the particular investment vehicles. So going through literally everything. The power to employ attorneys, accountants, agents, depositories, and employees, and to pay the expenses. The power to contract for the conservatorship and perform outstanding contracts and thereby bind the estate, including assisting or waiving confidentiality agreements. Asserting or waiving confidentiality agreements. You know what that here? Let me just read that again and let the impact of this sink in. The power to contract for the conservatorship and perform outstanding contracts and thereby bind the estate, including asserting and or waiving confidentiality agreements. The new conservator of the estate can waive any NDAs needed to allow people to speak freely if they so desire. Now, most NDAs don't limit you from speaking out against criminal activity and speaking out in investigations and speaking out to law enforcement, but they have the ability to now waive confidentiality agreements if they want to. I wonder how concerned Dad Spears is about that. You guys let me know in the chat. How concerned do you think James Spears is about the power to waive prior confidentiality agreements? Do you think there's concern? I think there's concern. The power to assert the conservatee's right in any trust established for her benefit, including but not limited to revocable inter vivos trusts. So this is dealing with trusts, estates, planning. They can change and move her assets. They can change and move the way things are set up. If this is an if Dad Spears has made himself like a benefactor or a beneficiary down the road if something happened to Britney, they can change all of that. They can change her estate planning and all of it, which is great. Parties are to meet and confer regarding a timeline to turn over documents and records relating to the conservatee and her assets. Which means Vivian has to get on the phone with Rosengart and with the attorney John Gold and talk about when they are going to turn over assets. The court orders the temporary conservator to post bond in the amount of $47.2 million. That's the same amount that Dad Spears had posted as bond. The court orders the temporary conservator to file an accounting no later than Tuesday, September 27th, 2022. So that would be the next accounting date a year from now. Look, when I said this is why Rosengart didn't want to terminate the conservatorship and leave Dad Spears in charge, it's because of this. When James Spears made the motion to terminate the conservatorship, it should just be gone. It was leaving him in power until all of the financial accountings are done. They have asked for the next accounting September 27th, 2022, a year from now. That's part of the reason suspension was so important. Not just the turning over of documents, not just the turning over of files, but that this is going to take a long time to finish all these accountings and investigation and wind it up. The court also set an OSC regarding the first account on Friday, December 2nd, 2022 at 8:30. So that is, hey, if we don't have it by September, you have to produce it by December. The petitioner is to prepare the order appointing temporary conservator, and upon signing of said order, letters shall issue forthwith. Those letters haven't issued, and I have not seen the order appointing temporary conservator. I imagine that we will see it this week. When we do, I will absolutely be sharing it on social media. So again, I keep saying where to find me, but we have over 5,000 people in here, and I know some of you are coming in and out. So do the likey things, subscribing things at the Emily D. Baker if you want the faster, quick bits, because those go on social. So I think we'll see the order soon. I mean, not like saying it, Sam Ingham taking 6 months to file the order, and then Bessemer Trust bouncing. They yoted themselves before it was signed. Well, the day after it was signed by the court because it took so long to file. All right. So let us see what else is in the other minute orders. So I'm going to go pull up all of the other things that were filed. There were a bunch of other minute orders. Lots happened in court. So let's get to those other minute orders. This was the big one. This is the one I will share on social because this is the one that says the things we wanted to see said. Look, this is the one that suspends James Spears. And that was the goal of this court hearing. I know that a lot of people are like, we want this ended altogether. Yes, but I'm a process girl. There is process that needs to happen here. And the process, it feels like, is finally going in Britney's favor and taking a logical and a thorough approach, also a strategic approach. So let's pull up the Rosengart objection. There was another Rosengart motion filed that I did not cover. It was filed on the 28th. I don't think it even populated on the court website till a few days later. So let's see. Conservatee Britney Spears objects to James P. Spears' petition for order allowing and approving payment of compensation to conservator and attorneys for conservator and for reimbursement of costs. Yes, ma'am. Introduction. The misconduct of Mr. Spears has previously been well documented, including, among other things, incompetence. Yeah, there it is. Severe and ongoing abuse of his daughter. Actually, I should timestamp this so we can get to this one too. Yay. Timestamps. And the dissipation of estate assets. The September 24th, 2021 New York Times front page bombshell expose and accompanying documentary shed even more light on his and his cohorts' horrifying alleged actions and the unfathomable lines he and others have reportedly crossed, including placing an illicit listening device in Britney's bedroom and capturing attorney-client communications. The allegations at issue obviously warrant serious investigation. In the interim, these reported actions cast his petition in an even harsher and more and deeply troubling light. For the reasons herein, all proposed fees are in question and subject to disengorgement and clawbacks. God, we love a disengorgement question. We love a disengorgement argument. Footnote 1. This is also true regarding his counsel's latest filing objections to the successor conservator of the estate. As Mr. Spears should know, California law expressly allows licensed CPAs to serve, and the nominee, John Zabel, is a highly esteemed, nationally recognized, award-winning CPA with an impeccable record of serving in positions of trust. In stark contrast to Mr. Spears, a reported alcoholic and gambling addict with zero financial background or experience in financial matters, who previously filed for bankruptcy and has a domestic violence restraining order currently in effect against him. Mr. Zabel will also be supported by Ms. Spears' business management and forensic accounting teams. Wow! That's a footnote. That is a footnote. He's an award-winning CPA. We have a forensic accounting team, and you, sir, are fucked. That's what that footnote said. Goodbye. Goodbye, 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 goodbye. I can't do Oingo Boingo justice. Goodbye, goodbye, goodbye. If you know Oingo Boingo, you know you hear it in your head too. Against this backdrop, set forth below are Ms. Spears' objections. To be considered reasonable, fees must be paid from a conservatee's assets. They must, at a minimum, have been spent in furtherance of the best interest of the conservatee. And this is exactly what's going to happen. They are going to keep arguing that these were not spent in Britney's best interest. The burden is on petitioner to establish that fees were incurred for actions taken that were in the best interest of the conservatee. So they're reminding the court that the burden shifts to the person asking for the money. You're asking for the fees. You have to prove that those fees are to benefit the conservatee. And all of the litigation against Rosengart's motions, he's going to argue, look, you're arguing against what we're arguing. We're arguing in the best interest of Britney. You're arguing against it. Therefore, you have to pay your own legal fees on that. Oh, wait, this isn't a footnote 2. I thought this was a footnote 2. This is a continuation of footnote 1. If footnote 1 has 2 paragraphs. What? 2 paragraphs on footnote 1. Okay, we have to get back to the sassy footnote. Footnote voice on a hoarse throat. Okay, back to footnote 1. Mr. Spears' desperation to avoid suspension is self-evident and self-serving. No shit. He wants to escape justice and accountability, but will not, and he will evidently do or say anything to avoid it. He knows that when he is suspended, he must turn over the conservatorship files, including purported attorney-client privilege documents, communications with his lawyers. I love that Rosengart is writing this sassy footnote for the entire world to read, not just lawyers, because it's like, by the way, that means the communications with his lawyers. That's what it means. That's what it means. They're explaining it within itself. Including purported attorney-client privilege documents to the new temporary conservator. In light of the most recent disclosures of his misconduct, according to the New York Times reporting, he is and should be particularly concerned about the release of these communications. No shit. To be followed by further interrogatories, questions under oath, and sworn deposition. And then it cites the law that we've already gone over from the last motion. And this is the same law cited from the last motion, saying this law, all of this is why you have to do that. So I'm not just saying shit. I'm backing it up. All right. God, that was a sassy footnote. That is a footnote to go down in infamy. Moving on. Here, the March 26, 21 petition of James P. Spears for order allowing and approving payment of 1, compensation to conservator, himself, and attorneys for conservator, his 4 law firms. 2, reimbursement of costs as supplemented does not carry the practitioner's burden to establish the fees and costs incurred were reasonable and for the benefit of the conservatee. Although discovery of Mr. Spears and his cohorts will expose additional issues and must be completed, whether or not Mr. Spears invokes the Fifth Amendment, before this petition can be resolved. There are numerous problems with the petition on its face. Accordingly, the conservatee lodges the following objections. I'm going to break this petition down in a separate motion, in a separate video, because we're going to have to get to this on Friday. There is so much here, but I want to get to the rest of the minute orders, and we're already an hour and 30 minutes in. But there is so much here. Let's see where he talks about the media matters. So, improperly charging for overhead and office filing tasks. So he gets into the general admin. The petition from Freeman and Freeman has general admin at 75% of the requested fees, totaling $427,000. General admin's on you, friends. And then he goes through why that shouldn't be paid in 5 points. Time wasted on petition to appoint Andrew Wallet as co-conservator, exorbitant time spent on efforts to get paid, and exorbitant time spent on unapproved and unfiled accountings. The fee petition supplement papers seek over $66,000 in fees related to work on conservatorship accountings. Damn. Insufficient description of tasks to the SJB trust. Overlap with Holland and Knight. The fee petition and supplemental papers make clear that the Freeman firm and Holland and Knight both worked on overlapping matters. That's bullshit. Let's get into Holland and Knight's petitions. Holland and Knight is where Vivian Thoren works. We call H&K Hell's Kitchen because in my mind, when I see H&K together, it reminds me of Hell's Kitchen. And I think it's funny. Outrageous and exorbitant time spent on media matters. The fee petition and supplemental papers seek over $530,000 in fees for more than 650 hours related to work on media matters. Problems abound. Problems abound is their version of I have questions. The fee petition papers do not identify who did what or when. Let's see. They are talking about, to that end, the fee petition papers identify various strategic communications advisors, some of whom are not even identified as attorneys, as providing billable services at hourly rates of $185 an hour, $500 an hour, $500 an hour, and $850 an hour. But the petition papers never delineate between tasks done by lawyers, tasks done by non-lawyers related to media matters, let alone why having non-lawyers involved was a benefit to the conservatee. Ouch. The petition papers also vaguely refer to unidentified consultants who worked hourly billing rates in the range of $35 to $650. The petition appears to try to shoehorn consultant fees of over $99,000 into media management costs without explaining for who explanation for who did the work. Why is media management necessary for the law firm working for the conservatorship? Media management costs? What are they managing? Let's see when they get to the $1.3 million, because they dig into this. Exorbitant time spent on unapproved or unfiled accountings, over $300,000 for more than 423 hours of work relating to the 12th accounting and 13th accounting. Exorbitant fees on business manager and miscellaneous matters. Remember, Holland & Knight is James Spears's law firm that's hired to represent him as the conservator of the estate, and their work is supposed to be for the benefit of the estate. But they are not the business management firm. Britney has a separate business management firm. And when TriStar quit, James Spears, with his attorneys, hired a new business management firm and said that Britney had no right to choose her business manager. It's in the legal documents that we followed almost a year ago, because Sam Ingham said to the court, this is part of why James Spears should be removed. He hired this new business manager and didn't even run it by us. And James Spears said she has no right to be infirmed. But what's coming back to roost is that that's not exactly the way. And why is Holland & Knight billing for business management when there is a business manager also on the books? The fee petition seeks over $115,000 in fees for 113 hours of work relating to business manager and other miscellaneous matters. Yet H&K was retained as litigation counsel. The petition does not establish how any of this work is within the scope of their retention as litigation counsel, because they're not business managers. Overlap with the Freeman firm we talked about. And then objections to Sidley Austin's requested fees. This is one of the other 4. I said James Spears had 4 law firms. This is fantastically broken down, and I'm in love. I love this. Love it. No declaration with personal knowledge. So Sidley Austin is law firm number 3 in this, seeking approval of $153,000 in fees, improperly characterizing fees as costs. Objections to Russ August Cabot's fees and costs. This is number 4 when we get to law firms. They're looking at 125 hours at over $96,000 in fees. Time spent on media matters. This is, I think, consulting with Holland & Knight on the media matters. Objections to James Spears's request for fees. James Spears attempts to justify his exorbitant charges of $16,000 a month plus $2,000 a month for office space by claiming he did his best to keep current regarding the music, advertising, and entertainment business. If he was keeping current, he would have let Britney have a TikTok account, because that is where music is moving forward. I heart this argument so much. But Mr. Spears is not the business manager, and this is not his job. Accurate. Mr. Spears also states he spent considerable time addressing issues that arose from the change in Ms. Spears' business management team, but Ms. Spears had already stated she didn't want to work again until Mr. Spears is removed from his post. So Mr. Spears also declares that he worked with his counsel to address issues arising from dramatically increased public media and social media attention to the conservatorship, which include major television and news articles, social media posts, global media inquiries, and documentary films. As established above, however, such media work was not and could not have been in the best interest of Britney Spears. Deny all of his funds. Don't pay him. Yeet Jamie's money too. Yeet Jamie, yeet Jamie's money. Did everybody hear the large crash of Jamie's gravy train crashing into a wall? Because that's what just happened. That is the end of the line for James Spears. I don't have a sound effect. I don't have a little soundboard. We're not that fancy here. Sound effect in your own head. Sound effect, whatever a crashing train sounds like. Emily, don't do it. Don't do it. Mouth. We're going there. Fantastic. Welcome to my ADHD brain. All right. This is another one of the 5-minute orders that were filed. This is the petition to appoint temporary conservator filed on September 22nd, 2021. This is the exact same as the beginning of the other minute order. The court suspends James P. Spears as success. Oh, this is the one we went over. It's exactly the same because this is the one we already did. Next. This is petition for appointment of successor conservator filed on July 26, 2021. The court takes testimony. This petition is superseded by related calendar matters. Accordingly, the court rules as follows. This petition is denied. The reason this petition was denied, because this petition was the one that was seeking to appoint the other individual, Ruben, not Zabel. So it's like, hey, there was a subsequent petition. We granted the subsequent petition. This is moot and irrelevant. All right. Next. Appointment, conservator of the person only successored, filed on March 23rd, 2021 by Britney Jean Spears. The court takes testimony. The court finds there is insufficient evidence has been provided to grant the matter on calendar on this date based upon the reading the moving papers and consideration. Appointment of conservator of the person only, filed by Britney Jean Spears, is denied without prejudice. Here's why that's good. This was Britney's motion that was filed by Sam Ingham ages ago to appoint Jody Montgomery as the permanent conservator of the person. This motion is just saying, no, essentially, Jody Montgomery is going to stay as the temporary conservator of the person, which truly just makes the most sense because now there's a temporary conservator of the person, a temporary conservator of the estate, and that's going to make it easy as we go forward to wind this down. So that ruling makes complete sense. Let's get to the next minute order. Ex parte petition filed July 7th by Jody Montgomery. This was the fee petition for security costs by Black Box. Remember, that's who Dad Spears had recommended. Jody Montgomery withdrew the petition. Things got less heated after Rosengart came on, and it seemed like the period of time from June 23rd to July 14th was very heated. There were death threats alluded to in the court documents. There was a lot going on. And during that time, Jody Montgomery asked the conservatorship to pay for her private security the way they were paying for James Spears's private security with Black Box. And Black Box, who was recommended, Edan was in all of the emails that were attached to the petitions, or at least his name was. And she withdrew that. I think after Rosengart was appointed, a lot of that settled down because people finally felt like Britney had at least a lawyer that she selected representing her. And some of this chilled out a little bit. Let's get to the next one. Notice of withdrawal petition. I think that covers all. Let me just pull up my files real quick. I think that covers all of the minute orders. Let's see. 1, 2, 3, 4, 5. Oh, no, one more. We don't need to go over the petition to withdraw because it was withdrawn and then it was moot. So this is the petition authority filed on June 29th, 2021 by James P. Spears. This was the petition to, this was not the petition to terminate. This was a different petition. This was the petition, I believe, regarding the funds, but I will have to go back and grant it because they didn't give the full name of the petition in the minute order. Yeah. The court finds that insufficient evidence has been provided to grant the matter on calendar this date based upon the reading of the moving papers. The petition is denied without prejudice. So whatever that June 29th petition is, let me go. Because I have these organized by date. Let me find what that June 29th petition is. And we'll just answer our own questions real quick so it doesn't noodle at my brain and make me absolutely crazy. That didn't even take that long. This is the response to Sam Ingham's petition for appointment of Jody Montgomery as conservator of the person. That's already been rendered moot. Petition for instructions in order investigating issues and claims. That's also been rendered moot. That's from June 29th. Let's see if there's anything else from June 29th. And then this is from June 30th. So no. So it was one of those two that the court was alluding to, but they are both moot at this point because the stuff with Jody Montgomery's been withdrawn, and the stuff with Sam Ingham is irrelevant. So whatever the request for an investigation, that's happening. It's just not happening by the court. It's happening with Rosendaddy. That's who it's happening with. So those are the most recent filings in the Britney Spears case. I will do a shorter video going over the objections. I feel like we need a video rounding up everything that's going on with the 12th accounting. That'll take me a little time to put together, but I think that what I'll do is just put together everything that's going on with the 12th accounting, because the 12th accounting is where this fight's going to heat up. Now, like step one, get rid of James Spears. Done. Check, ding. Yes. Love it. Live all of it. 2, fight over the money. 3, end the conservatorship. So fight over money and then free Britney is where we're going next, because we want Britney to get some of her money back, bitch. There's a $47 million bond out there. And if shit was being approved, we can start clawing back some of that money. So I'm sure you have questions. I have questions. Let's just get into questions at an hour and 45 minutes in. Can we get some love to the mods? Because the mods are just handling it. Can we just mod love for the mods? I appreciate you. Let's get into questions. Okay, before we get all the way into questions, if you have not joined our Patreon and gotten the I Have Thoughts podcast, it is my members only podcast. I'm going to try to put the link up here. You are welcome to come join it. Next week is our members only live stream. If you are a member of Patreon, you have access to that. If you just want to be a channel member and have your sassy little gavel, you can just hit join above and you can do that. But the members only podcast and our chitty chats live now over on Patreon at lawnerdsunite.com. And we have our next live stream coming up, a new episode of I Have Thoughts coming up, where I will be talking more about not just Vid Summit, but also going out to dinner with Queen Levine and Saltsy and my dear friend Abby, who is running for judge in LA. And we had lawyer chats. We had lots of thoughts, lots of laughs. And it was fun to meet people I don't know, but have been thrown together with online in person. We chatted about harassment against our kids and the threats that we received during the defamation case, about investigations. It's been very interesting. So if you're interested in that, that will be over on the Patreon. If you just want to be a channel member, the Law Nerd tier will absolutely get you there. You get your sassy little badge that color changes up to the year point. You get to celebrate your anniversaries in the chat. If any of you members can do that, you are now able to celebrate your member anniversaries in the chat. Like you have a special little thing. I just got notice from YouTube in my studio that that's available. All the things. So thank you for the love to the mods. That's where Patreon is. You know where I am on social media. Don't forget to follow me at the Emily D. Baker. Let's get into questions. I'm going to try to get to some super chats. If I miss some, I love you. I apologize. Root cause analysis. Dad Spears lacks full sophistication to orchestrate. Get at the root of. Oh, we binged. Get at the root of the continuous perpetration of human rights. I agree with you. There is a bigger issue here in the courts. But with regard to Britney, it is very much getting rid of her dad and then digging in deeper. And now that the files are being turned over, they will be able to get to it. But yes, just because Britney is having, after 13 years, a better outcome, doesn't mean that there aren't still big issues with the conservatorship system and oversight in LA. It seems that this one has been particularly egregious. Yes, I'm sure there are others. Yes, we will talk about others. But, you know, even the leaked reports we're seeing from the New York Times is showing that the investigator was saying to the court, look, this isn't a healthy arrangement. Back in like 2014, 2015. So we absolutely know that there are big problems here. God, we're almost at 160. If we hit 160 on Friday, our Friday night live stream is going to be the giveaway of these cups. So go ahead and share this out to anyone who loves the content. Remind them to subscribe, and we'll do a giveaway for the matte black Law Nerd tumblers on Friday. So should we celebrate that it binged? It Chanandler binged versus Chanandler bonged. Oh, it binged! Move your head! Ah! We absolutely binged. For all of you that are new, it's when the counter ticks over. When the channel started taking off, this thing was ticking over multiple times a live stream. Now we're at the thousands, and it ticks over a few times a week. So this is the bing that we are all speaking of. You hear the little bing back there. So bing. There is supposed to be conservatorship oversight. The problem is, all of the oversight is within the system itself. There isn't external oversight, and that is absolutely an issue. So that is that is part of the thing. All right, let me try to pull up in the back end of the channel some of the super chats that I missed while answering some of the questions that have come in while I have been prattling on. Question: if Britney lives in Thousand Oaks, why is this conservatorship not in Ventura County? And would it be the Ventura County DA to go after Jamie, or would it be that the bad LA DA? So, Rachel, there are lots of very good DAs within LA. Lots. There are strong feelings regarding the head of the office, but the head of the office is a political position that will come and go. So that is what it is. I think that I think that there is probably federal interest in this case, but it can also be state level. And because a lot of the actions happened within LA County, this is like based on 7 levels of it depends. It depends what they go after Dad Spears for. If it's abuse within the conservatorship system, money and stuff like that, it can be within LA, but it can also be federal. And so I won't be surprised if this ends up being a more federal investigation than a state level investigation. It doesn't mean it can't happen at the state level. I just don't think that it will. Excuse me. Can Britney go back through the first through 11 years of accountings and clawback funds? I have not seen Rosengart touch on this. Some of it's hard because it's been approved, but if there is malfeasance or if there was, fraud and things like that, you can go back to the statute of limitations and you can go back to some of that if the court wasn't aware. If the court was aware of everything, it's going to be much harder to claw things back after the fact. So unfortunately, it's very hard for me to speculate on because it really does depend on what they uncover. I'm sure that Rosengart is focused on uncovering everything that he can for his client. Again, he's a former prosecutor. At this point, he's probably like, oh, fuck no, bitches, what we're not going to do. I would just be curious. As a prosecutor, prosecutors tend to be very curious. It's like, I want to know where everything is. Team, what we're doing is going through all of this. And if the books aren't matching up with things that are said to the court, you have a better chance at it. And yes, I'm sure they will investigate it to see if there's anything that can be clawed back. Absolutely, for sure. You guys, we've had a ton of super chats come in during this live stream. I am going to try to get to as many as I can. If I don't get to all of them, I apologize. I appreciate you. Linda says, girl, it's good to have you back. I didn't know what I did with myself all week. I know I will be mindful of taking breaks. Grace K said, thank you for always being a voice of reason. JC said, as a close family member of a murderer, I feel for the Laundarie family. People absolutely persecute us based on the actions of our relatives, and it can be extremely horrific and traumatizing. JC, I feel for you. Absolutely. Thank you for sharing that in the chat. I think it's a testament to what the Laundarie community is. You can't control your family members. And I've absolutely seen this in court. And it's something that's always hard to watch play out. Particularly, I did a lot of vehicular homicide cases during a period of my career that was particularly unpleasant for me. And it was hard to watch the families of the defendant because most of the vehicular homicides were alcohol related. So somebody in their family chose to drink and drive and killed someone. And for the family members, they're like, that's somebody's choice. That's a horrible choice. That's a bad choice. And a horrible thing happened. And this is still our family member. There's a lot of conflict there. So thank you for sharing your perspective on that. I don't like watching the way people are attacking the Laundarie family. If his parents helped him, and that comes out, then they will have their day in court, won't they? They will absolutely. But for now, it's hard to watch them getting harassed outside of their home, especially for his sister. So yeah, it's just can't wait until Lou Taylor and Jamie Lynn Spears are exposed for transferring money to TriStar, and then the company lost $500 million, if I'm correct. I know that Jake Yonsei and That Surprise Witness are doing a deeper dive into Lou Taylor, so we will definitely be seeing more looking at Lou Taylor for sure. Question: if you were repping Britney, would you confirm her communications with Ingham were her after the New York Times revealed that they mirrored the Apple devices? And Team Khan could have communicated as her. It depends on what I saw. I would definitely go back through. I would take the time to go back through everything. There's some immediate need in this case that needs to happen first. But yes, there are definitely some questions. And hopefully Ingham is open and talking with Britney's current legal team, and they're able to kind of figure out what the fuck was going on there. Let's see. I'm going to see if there's any more questions in the super chats. Thank you all for them. Heidi K, thank you for the super chat. Danielle, thank you for the super chat. Know that I do see them, so thank you. Mother of 4 cats, this is to chip in for the transcript. Thank you. Jordan T, Britney expressed to the court investigator that she wanted the conservatorship to end. Would Sam Ingham have gotten a copy of that report? Sam Ingham would have had a copy of every single investigator report. Everyone would have. Sam would have. Dad Spears and his legal team would have. Everyone involved would have had a copy of that report. That is so loud. A very large truck doing large truck things out there. Mr. Rogers Charlie asked, when is James Spears allowed to let his surety bond expire? Is Britney's new conservator the only one who has the authority to release the bond? I don't know the ins and outs of the bonding. I can't imagine that until at least the 12th accounting is done, that there could be a release of that bond, because his accounting parts are not wrapped up. So there would have to be a final and approved accounting for that to happen, which is going to be a while, I imagine. So thank you, Ashley Vincent, for the catnip tip. I appreciate it. Question, do you have any idea about the idea of the special witness or people that leaked court documents to the New York Times? Thanks. Love your commentary and analysis. Sarah, I'm not sure what the question is. Could they be witnesses? Yes. Right now, the only person who has the authority to go after them for the breach of the NDAs is the new conservator of the estate. And I imagine that won't happen. So we will see what happens there. Mother Oates said we need the unlimited funds up for investigation by the feds. I think so too. And I think that will be a part of it. It will have to impact interstate commerce. I think there's an argument that it can, because the conservatorship owns property in multiple places, and Britney worked in Vegas and worked in LA. I think you can find an interstate tie to it to give federal authority. So chronically witty. I love that name. Only 40% of us have liked this. Like it. Yes, like the video. There's over 4,000 of us here. Go ahead and do the YouTube things, the likey, subscribey things. Follow me on the social things. Appreciate you. Let's get into some more questions. Let me know where we're at with likes so we can yay about it. Yay. Like that. You can hear the tired voice, right? Question, can they sue the court or the judge for enabling this for years? No. There are very limited things that they can sue a judge for. Judges have absolute immunity when acting in the course of their duties. Now, if they find, and I hate speculating on this because I don't want it to be like, Emily said there was criminal malfeasance. If there is criminal malfeasance, absolute immunity doesn't always cover it. But if it's just like, oh, well, you approved the second accounting, and the second accounting wasn't objected to by Britney's lawyers, but there's things in it that maybe shouldn't have been approved, you can't go after the judge for that. The judge is allowed to approve accountings, things like that. So it would be a very rare instance where you could go after the judge. You cannot sue the judge because that is a civil remedy. But if there was criminal malfeasance, and I'm not saying that there was on part of the judge in this case, in general, criminal behaviors are not protected by that absolute immunity that the bench holds. But civil remedy is like, I'm going to sue you for causing me emotional hardship, for sending me to jail. You can't do that. Or for approving these, you can't do that. Do you think Tom Girardi will be exposed in the Pandora Papers controversy? Could you please do a live breaking down the Pandora Papers? I have not even pulled into them yet, so it will go on the docket of new shit that I have to pull into. We have a lot of active cases going on right now, but yes, we will absolutely look for it. Pocket Angie Tips, good to see you, friend. Will Dad Spears have to pay for the 4 law firms from the day he was yeeted? Yes, and possibly before that. One more sip of coffee. Question, correct me if I am wrong, but can he, Rosendaddy, I'm assuming, continue to investigate and file against James P. Spears even after the conservatorship ends? Yes. Some of this stuff is easier, I think, when you have the jurisdiction of the court. I like that we have the jurisdiction of the court. I think that that's appropriate, but I think the goal is getting the court to facilitate the transition of documents. Once the transitions of documents is done, then we have a little more room, I think, for them to continue to investigate. But when he says he wants this done in the fall, that means that to me, that indicates that Rosengart has a plan for how they want to pursue any investigation and depositions and things like that, because you do still need authority of a court. It just might not be this court, which means they can take this elsewhere and it would go out of probate court into another civil court, because then it would become a different civil matter. Hope that helps. D. Murray questions, since he had listening devices in each state she was in and when she was overseas, would it be federal? Can absolutely. Can he be prosecuted in each state? I think they would try to coordinate it because, well, ease of effort and dilution of funds. But it depends on the different states' rules and laws regarding that. And then the federal rule and law regarding that might be a little more beneficial. Oh, my lip. Question, are there consequences for Jamie's lawyers, and what would they be for everything they've done? Well, Jamie's lawyers have been doing, y'all aren't going to like this answer. We're going to put on some lip gloss for the unpopular opinion here. Yeah, we're going to definitely, I'm almost out too. I need more of my pink frosting lightsaber lip gloss, which I'm going to be ordering after this. It's like, we're almost empty. Okay. James's lawyers were supposed to be acting in the best interest of the conservatorship. So they're supposed to be acting for their client to protect the conservatorship assets, to protect the estate. I think there's definitely evidence where we can say it feels like they weren't working in that regard, but they owe a duty of loyalty to their client. I see their client as being the position of conservator of the estate, not James Spears, the person. But some of those remedies would be ethical. They would not necessarily be liable for something. So they have been vigorous advocates, it seems to me, of James Spears. Whether that has gone outside the bounds of their duty to the position of conservator of the estate is yet to be seen. So could there be consequences? It depends. Like, if they're complicit in recording and they knew that these were not court approved, that's a whole different situation than if they were just douchey in court, if that makes sense. So we need more information before we can speculate on all the bad things that might come next. I'm going to try to get to a few more questions. I see that you guys on over on Facebook. Hello, Facebook friends. What if Daddy and his cohorts delete documents? Hopefully they'll be able to track them down. They shouldn't be. They're under an obligation to preserve. And it would be bad if they did. And there could be repercussions for that. Question, Ali C. I'm not American, so please forgive the question. All questions are welcome. You overestimate how much Americans understand of their own legal system. Our system, I believe, is intentionally confusing, and that goes ditto for our tax system. How does a case change if it's federal rather than not federal? So in the US, we have federal cases and state cases. State cases are prosecuted at the more local level. Generally, the biggest issue is resources. The federal government has more resources to investigate these cases. Their prosecutors have more resources. Their investigations tend to take longer, and their authority and jurisdiction more easily extends for multiple jurisdictions in multiple states. For example, Britney being in Ventura County or living in one county and having the conservatorship in another county means two different DA's offices and different law enforcement agencies with different jurisdictions have to work together, and that can be more difficult because of the rules regarding jurisdiction. The feds can kind of cross a lot of those boundaries because their authority is over the whole, not just the counties. You know, we've got in California, there is the state's attorneys general, there is the U.S. AG, and then you also have state level prosecutors like the LA County DA's office. But then within that, you also have prosecutors at the city level, like the city attorney's office in Santa Monica. So it's like the more you drill down, the less resources you have is generally the way that works. Papers in the UK are reporting that Britney's house was swept for bugs when she was on holiday. Will there be legal punishment if anything was found? We will see what happens next, possibly. And I'm glad she was on holiday. Did you guys see Britney just absolutely having the greatest time in French Polynesia and flying planes and talking about islands and being naked on Instagram? It seems like Britney is living her best life and flipping the bird to her dad. So Casey said, your hair looks really good straight, by the way. Well, thank you. Sometimes we're straight, sometimes we're curly, sometimes we're up in a bun, sometimes we're under a hat. Either way, we are very, very purple. Question, do you think Judge Penny ruled in Britney's favor because of public pressure? I would be remiss if I said I just thought the judge was doing what was in the best interest of Britney. Because if she's doing the best interest of Britney, why didn't she do it a year ago, 2 years ago, 5 years ago, 10 years ago? So I think that Britney speaking in court and the whole world hearing it impacted what happened in court going forward. I think Britney speaking in court on June 23rd and saying, no, I want this open, impacted Britney being able to hire her own attorney on the 14th. And that impacted what happened in court. So I don't know if it was public pressure or public awareness, but Britney did this. And I don't want to take away from that and downplay that Britney saying enough is enough again. Even though the court hasn't listened to me before, I'm going to try again. And Britney going into court to be heard again while the remote audio access program was going so that it could be public. The judge not allowing other attorneys to seal the court because attorneys did ask this proceeding, the 23rd, to be closed to the public so that whatever Britney talked about would not be publicly known to protect her medical privacy rights. And Britney's like, no, I want to be heard. She did this. Britney's plea to the court was finally heard. And I hope that maybe seeing the public's reaction helped Judge Penny see this case through fresh eyes and see the circumstance through fresh eyes. I also think that Matthew Rosengart helped bring a refreshed perspective to this, which is something Britney's lawyer was not getting done. And I don't know if it's just that everybody had blown off Sam Mingham for so long that they didn't hear him anymore. I don't know if he got tired trying. I don't know if he was trying to make nice with James Spears because he was worried about how he was going to get paid. I don't know. But everything changed on the 23rd. And the thing that was the biggest part of the 23rd was Britney speaking to the court from the heart with no fucks given, begging for her life, essentially. And that changed everything. So public pressure, I think, helps, but I think Britney did this. So hopefully that helps. The new conservator, Zabel, will want people to come forward with their experience. So going against the NDA isn't as frightening. I think so. And I think the fact that Zabel can yeet those NDAs helps. Also, I forgot to pull these up, but Zabel also filed all the acknowledgments of the positions. Hold on, wait. I will do that on Friday, but he signed all the duties of conservator. So the legwork is there. I will touch on these briefly on Friday, but these are really just form agreements saying, yes, I'm a professional. Yes, I consent to serve. Yes, I know the duties and rights of the conservator. We'll go through these and I'll point out anything that might be interesting in light of how Dad Spears carried out this. But I'm hoping that by Friday, what we will have is the papers or at least the order, the official order, so that we can see the papers. So that's what we're going to do. To me, this sounds like a RICO case. Maybe. I mean, I think that's one way to go. This was an enterprise for sure. And I think this needs to be a consideration, especially when they see the way that RICO was used against R. Kelly. And though the wrongdoing is different, the use of an organization and defining a criminal organization in the context of an entertainment business is going to be very illustrative to prosecutors moving forward if they look into this case. But again, we got to get to a lot of what ifs to get there. My voice has yeeted me. My voice is done. I'm going to do just 2 more questions and then I am going to have to bounce because you can hear it. A huge thank you to the mods. Thank you to all of you for the 2,000 likes. Gibbers, an example of criminal malfeasance, criminal wrongdoing, fraud being the one that comes to mind. Fraudulent transfers, fraudulent payments, fraud upon the court, perjury in court documents, things that could be related to this case. This is not things that are related to this case. These are down the line things that I would be looking for. I'd be looking for perjury, fraud. I mean, the illegal listening for sure, the illegal tapping of phones for sure. Those things, the listening devices become kind of the easy in for a criminal investigation. And then you can kind of crack it open. Remember, these things take time. So you're not going to see I don't think, of a criminal investigation for quite a while on this. This is something that is going to take time to put together. And when it starts rolling, look, the Jen Shaw indictment alleges behavior back to 2012. She got indicted in 2021. Things do take time. Absolutely. Jack said, your voice is ASMR to me. Love your channel. Thank you. I've been remiss on my ASMR legal channel where I read the Constitution. I have more legal documents to get to, lots more. I've just been swamped. That is part of the goal going into 2022, is making sure that I can also keep that channel going, because it was a lot of fun to do. And it was a challenge for me to do dramatic readings of historical legal documents because they're written in older English. Uncovering hypocrisy. Hello. If I were you, once things have come down a bit, would you sue Edan at Black Box? It depends. That's a strategic call. It depends on who their bigger fish is. So do you sue Edan? Do you let the feds get to him? Do you try to flip him as a witness against James Spears and Team Con? Do you use him and the employee as the point people? Do you wait for Edan to come to you and say, hey, I know everything. I'm happy to tell you I don't like prison. So I think there's a lot of strategy here going forward. And right now they are trying to, I think the next steps that I'm seeing are get rid of Dad Spears, fight over the money, end the conservatorship, continue to investigate. That's how I see it. Motion to call him Rosengart. I mean, I feel like that's a lot. I like Rosendaddy because it's cheeky. I think Rosengoat also works. I don't think Rosengart would say he's the greatest of all time. I think what he would say, and what we've seen him say in interviews, is Britney had the courage to stand up. Britney had the courage to cry out to the court, and she allowed us to come in and just take over and make sure that what was right needed to happen. He's been very humble. He has not taken this upon himself. He's like, look, we did our job. Like, let's all remember that this is our job and that this should have been done for her. And what happened before my watch is what happened before my watch. We're going to evaluate it, but we're setting a new course going forward, and we're not suffering any shit. So we are just taking the courage that Britney has had, putting a law degree behind it and marching it into court and saying enough is enough. And I think that's very important here. All right. Thank you guys for all the love. Thank you for the love to the mods. Thank you so much. I also think Rosengart is an amazing strategist. I think he has a good team working with him, and I'm very, very happy about that. We will have to talk more about Rico on Friday. I'll make a note. And it's not like Rico Suave. Na, 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 na. Rico. Na, 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 na. Suave. We're not that kind of Rico Suave. We're talking about racketeering. Racketeering. It depends. Racketeering can be like conspiracy, where with the right evidence, it's not that hard to prove because you just have to prove those predicate acts. We will talk about that more in context because they did use it in the R. Kelly case. I was a white collar crime law nerd in law school. So RICO is one of those things I feel nearly and dearly about. We will talk more about RICO on Friday. So thank you all for being here. Thank you so much. I've told you to do the things, the YouTube things, the thank you to the mod things. Go follow me on social. I will post links to all of this once this live ends so that you too can commemorate with this particular minute order and be a part of this historic moment for Britney. And I hope for this historic moment for all of us where there is more light on conservatorships that are abusive without taking away those that are necessary. So I appreciate all of you. Thank you for being a law nerd. Thank you for being here. Cheers. I will see you Friday for Friday Night Live. New Emily show live tomorrow. I will share all the things in the text crew, textemily.com. Yeah, there's lots to promote. It's all in the links below. Like, subscribe, do the things. Love you. All right. Bye. Connect with me everywhere. I'm at the Emily D. Baker. If you guys want to join the text, just textemily.com. If you want to join the channel, lawnerdsunite.com. Happy to have you. Support what we do here on the YouTube.